This is another video from TPA Transfer of Property Act. Now chapter 2 deals from section 5 to 53A and part 1 section 5 to 37 applies over both movable and immovable property, in which rules dealing with transfer 5 to 10 we can say these are kind of general rules. However, chapter 2 section 5 to 53A are rules itself, but for the purpose of understanding part 1 we can say 5 to 10 deals with general rules. Then rule related to alienation and enjoyment of the property, section 11 to 17, and it consists of rules against perpetuity and transfer in favor of unborn. Then conditional transfer, it consists of doctrine of Cyprus and doctrine of acceleration, as well as doctrine of accumulation. So now then doctrine of election, section 35. For all of these there will be separate videos covering the section. Then part B, section 38 to 53A deals basically with 3 points, that is rule related when conflict of interest is there, 38 to 43, and then 48 to 53. Then rules related to joint ownership, 44 to 47, and part performance, 53A. In this video we'll deal with section 38. 38 says transfer by person authorized only under certain circumstances. So basically it talks about transfer by person authorized, then only under certain circumstances to transfer. So first part, transfer by person authorized only under certain circumstances to transfer. So now this person is authorized, ये व्यक्ति, ये इंसान, he is authorized to transfer but only under certain circumstances. Now what section talks about? Section says, look, I am using bare act language here, and if you can decode that it would be very good. You need to have command over bare act also, otherwise by listening my commentary you can easily get the section आपको समझ में आ जाएगा. I have used bare act language here. Where any person authorized only under circumstances in their natural variable to dispose of immovable property. Where any person authorized under certain circumstances. This person is authorized under certain circumstances only. जब ये certain circumstances होंगे तभी वह इंसान व्यक्ति authorized होगा प्रॉपर्टी को ट्रांसफर करने के लिए. In their natural variable to dispose of immovable property. The sentences just cover that yes, there are circumstances. Now we'll come to example later on. And this person who is authorized to transfer only under certain circumstances has transferred such property for consideration. And this person who is authorized only under certain circumstances, he is alleging the existence of such circumstances, that yes, such circumstances exist and I am making the transfer. So they shall meaning thereby the circumstances, as between transferee on one part, transfer on the other part, and other person, third person, if any third person is there who is affected by the transfer of property. Okay, so they shall means these circumstances between the party, transferor and transferee, and any third party, if there is any third party, these circumstances will be deemed to have existed. It will be deemed that these circumstances were existing at that point of time. If the transferee, after using reasonable care to ascertain the existence of such circumstances, has acted in गुड फेथ, अगर जो ट्रांसफरी है उसने रीजनेबल केयर का प्रयोग किया है, यूज किया है, और उसने अपने आप को असर्टेन किया है, अपने आप को श्योर किया है कि हाँ वो सर्कमस्टांस एग्जिस्ट है और गुड फेथ में उसने प्रॉपर्टी ली है. नाउ विल लुक एट द एग्जांपल. एनी पर्सन अथॉराइज्ड ओनली अंडर सर्कमस्टांसेस इन देयर नेचुरल वेरिएबल टू डिस्पोज ऑफ द प्रॉपर्टी. फॉर एग्जांपल guardian or karta of Hindu undivided family. Now guardian takes care of the property of minor. कर्ता जो अनडिवाइडेड फैमिली है उसकी जो प्रॉपर्टी है उसके लिए डिसीजन ले सकता है. तो ये व्यक्ति प्रॉपर्टी को ट्रांसफर कर सकते हैं specific circumstances like necessity and emergency. Now suppose this guardian, he is taking care of the minor, and in order to give basic necessities of life to minor, he has no other means but to sell the property. अब इसके पास और कोई जरिया है ही नहीं, सिर्फ एक जरिए के कि वो प्रॉपर्टी की सेल करे और इस नेसेसिटी को पूरा करे. और फॉर एग्जाम्पल करता ऑफ हिंदू अनडिवाइडेड फैमिली, सिमिलर फॉर बोथ सिमिलर circumstances may work, like some emergency, some medical emergency, some financial emergency, some provision of marriage is there. So in case of minor, provision of marriage will not come, it will come in case of major only, so put it under the karta of HUF. So now it is considered that these circumstances, necessity, emergency and so on, they have deemed to have existed. Now we'll see the important rules. The transferor is having limited power of transfer. जो transferor है उसके पास limited power है, जो हमारा section का head note भी बताता है, only under certain circumstances to transfer. Now the section protects the transferee from such manager or transferor. Now this section basically it protects transferee. ये transferee को secure कर रहा है as against manager or transferor. Look, technically you can say that transferor is also being protected because he can say that necessity was there, so he made the agreement, whatever. But the basic scenario comes to this part also. Then transfer is required to have satisfied himself, means reasonable care has been taken by transferee. Now this is one important point. Transferor is not liable to, this is transferee, not transferor. Transferee is not liable to check where the money has been used. जिस व्यक्ति को प्रॉपर्टी ट्रांसफर की गई है वो है ट्रांसफरी. तो ट्रांसफरी की जिम्मेवारी है कि वो सर्कमस्टांसिस को चेक करे कि नेसेसिटी इमरजेंसी वाले सर्कमस्टांसिस हैं या नहीं. लेकिन ट्रांसफरी की ये जिम्मेवारी नहीं है कि वो ये चेक करे कि पैसा उस नेसेसिटी और इमरजेंसी के लिए यूज हुआ है या नहीं हुआ है. दिस इज नॉट द लायबिलिटी ऑफ ट्रांसफरी. नाउ बर्डन टू प्रूव नेसेसिटी लाइज ऑन transferor. If any condition occurs, then burden will be on transferor. Let's see some cases. Hunooman, Prasad, Panday versus Mussumat, Munraj, Koonweree. Now what are the facts? Facts are, widow out of necessity mortgaged the property belonging to her minor son which was succeeded from his father. So widow के पास property थी लेकिन उस प्रॉपर्टी को नेसेसिटी की वजह से उसने बेच दिया. प्रॉपर्टी बिलोंग करती थी माइनर सन को, सक्सेशन के थ्रू थी और विडो वाज टेकिंग केयर, बट इन ऑर्डर टू मीट आउट दिस नेसेसिटी उसने प्रॉपर्टी को सेल कर दिया. शी सोल्ड दी प्रॉपर्टी. नाउ इशू वाज वेदर कर्ता और मैनेजर कैन एलिनिएट माइनर्स प्रॉपर्टी और इंटरेस्ट. दिस वाज द इशू. सो कोर्ट सेड दैट विडो वाज रेस्ट्रिक्टेड ओनर एंड mortgage should have been done in case of necessity and it has to be proved by widow. Now I'll put it like this. I think then it will be much easier to get it. Fine. And necessity was that if she did not mortgage, then she is not able to pay revenue tax and property will be confiscated by the authority. अगर property को mortgage ना किया जाए तो property पे जो tax है वो नहीं चुकाया जा सकता, और वो टैक्स नहीं चुकाया जाएगा तो प्रॉपर्टी को गवर्नमेंट कॉन्फिस्केट कर लेगी, अटैच कर लेगी, उसकी कुर्की हो जाएगी फिर. सो नाउ इशू वाज इफ सो व्हेन एंड टू व्हाट डिग्री एंड अंडर व्हाट कंडीशन कर्ता और मैनेजर कैन एलिनिएट द प्रॉपर्टी. When you will study who can be karta, then usually women are not karta, but in case in circumstances women can be karta. There is no specific rule that women can never be a karta. ऐसा कोई specific rule नहीं है कि women कभी करता नहीं हो सकती, फैमिली की वो हो सकती है. Now and in this case court said necessity was well established. जो नेसेसिटी सर्कमस्टांसिस थे, जो नेसेसरी सर्कमस्टांसिस थे, नेसेसिटी थी, जो जरूरत थी, उसको एस्टैब्लिश कर दिया गया है. Since property was about to be confiscated, in order to protect it, property was mortgaged, transfer was valid. Now this case is decided on odd law when women did not have any share in husband's property. But if similar circumstances happen, suppose she is having property on behalf of minor, then it will be perfectly valid. Now widow has right, but there may be other consistency which you may understand when you will be studying succession and maintenance provisions. So this is for section 38 only. In next video we'll cover section 39, and as I told you, this part 1, then again we'll be having videos shortly.